Ripple versus SEC. Could newly released document tip the balance? The court case between SEC and Ripple Labs has been ongoing for nearly 2.5 years, but a summary judgment ruling could be made any day. The Hinman documents refer to a 2018 speech given by former SEC Director William Hinman and documents associated with writing it. Putting aside the fundraising that accompanied the creation of Ether, based on my understanding of the present state of Ether, the Ethereum network, and its decentralized structure, current offers and sales of Ether are not security transactions. This was considered a landmark speech as it signaled to the crypto industry that it could be possible for cryptocurrencies to transition from securities when they are first created to commodities once they're sufficiently decentralized. This could have an impact on Ripple's fair notice defense, which comes into play if Judge Annalisa Torres finds that Ripple did indeed sell unregistered securities. Ripple requested the documents in discovery, and the request was granted on October 21st of 2022. While the documents could be used as part of Ripple's defense, the SEC has attempted to keep them sealed on multiple occasions, arguing that they are irrelevant to the court's summary judgment decision. But on May 16th, Judge Torres ruled that the Hinman documents are judicial documents, subject to a strong presumption of public access, and denied the SEC's motion to seal. Notably, the court did not state whether the documents will be relied upon when it decides on a summary judgment motions on each party. But given the statements of those who have seen the documents, it appears likely that they will negatively affect the public image of the SEC. Courts could decide to fine Ripple for its early sales of XRP, relating to the initial coin offering and other transactions aimed at boosting the network. But the secondary sales of XRP and the coin itself are not securities. In a May 17th Twitter thread, prominent pro-crypto lawyer Fred Rispoli suggested that the summary judgment ruling is already written and could be issued any day now, while also agreeing that a split decision was the most likely case. And the whole fact that the SEC tried to seal the documents is just telling that what is in these documents. They got granted October 2022. That's like 7 months ago. I wonder what's in them. We will see. Ripple could be fined for what they did in the past when the tokens were securities, but they probably aren't securities now. That is the same kind of resolution SEC had with EOS. They fined EOS and gave them a waiver, said, hey, it's under the bridge. You can go on and move forward. I think that's what's going to happen with XRP2. We just don't have to get a negative outcome. As long as the SEC doesn't win, I think that's a win for Ripple and the crypto industry. Now, I think this whole thing with the SEC and Ripple was the SEC's way of punishing Ripple, whichever way this goes. And I think people are assuming the worst when I think they should be assuming the best. It's going to mean something and being very significant for the crypto industry. And Lord only knows if Ripple actually wins, how bullish that would be.